Hello everyone, I'm Nazarat Fatima. Welcome to Livelaw. We're aware of the curious case of Senthil Balaji. In the month of June, DMK leader V. Senthil Balaji was arrested by the Enforcement Directorate for his alleged role in a cash for job scam in the state, which is believed to have taken place between 2011 to 2016 during his tenure as the Transportation Minister under the then AIA-DMK regime. We have made videos on the background of the case, which you can easily access on our YouTube channel. Or also, if you want to read about the details on the case, it's a click away on our website. So in this video, we'll mainly talk about what all has been put forth in the Supreme Court by Senior Advocate Kapil Sibal. To begin with, a bench of Justices A.S. Bopanna and M.M. Sundaresh was hearing a batch of pleas in connection with the ED seeking custody of Mr. Balaji. In this video, I'll take you through some of the submissions that Senior Advocate Mr. Kapil Sibal put forward in the Supreme Court with regard to the question of difference between the power of the Directorate of Enforcement to make an arrest under the Prevention of Money Laundering Act 2002 and the power to seek the remand of an accused in its own custody. Mr. Sibal told the court, and I quote, "The investigation by the Enforcement Directorate is an inquiry for the purposes of the Prevention of Money Laundering Act. In other words, the ED officers conduct inquiries, gather evidence and make arrests once a conclusion of guilt is reached before filing a complaint. All statements recorded during this inquiry are admissible. Now, in this context, the question arises, if ED officers are neither police officers nor officers in charge of a police station, and the investigation is in the nature of an inquiry, then under what power will they seek police remand?" Mr. Sibal argued before the Apex Court bench today on 27 July that the Enforcement Directorate seeking custody of the minister was illegal because they were not police officers under PMLA. To support his argument, he referred to the decision of the Supreme Court in the 2022 Vijay Madan Lal Chaudhary judgment. On being asked by the bench as to why the central agency could not seek police remand even though it had the power to make an arrest, Mr. Sibal said, "In regulatory statutes, the police is given the power of remand and not the officer of the concerned agency. Under the Customs Act or Foreign Exchange Regulation Act, there is still a specific provision which allows an officer, as the officer in charge of a police station, to grant bail in case of bailable offences. For non-bailable offences and further investigation, the officer will hand it over to the police. Even a provision like this does not exist in the PMLA." He also used the examples of the Customs Act 1962 and the Foreign Exchange Regulation Act 1973 to illustrate his contention that the power of arrest did not necessarily confer on an agency the power to seek police remand. He said, and I quote, "Can a FERA officer seek police remand? He has the power to arrest. No. Can a customs officer who also has the power to arrest seek police remand? The answer is no. In a customs case, for example, after a person is caught and their statement recorded, they are handed over to the police authority who seek remand. Under the Code of Criminal Procedure, even a private person can make an arrest. Will he get remand? No. There is no such law. A person has to be a police officer or an officer in charge of a police station in order to seek remand." He also made an interesting submission regarding the position of ED officers, and as per him, whether they're police officers or not also depends on how the court has observed in Vijay Madan Lal Chaudhary judgment. He argued, and I quote, "In my opinion, the Vijay Madan Lal Chaudhary judgment is wrong and the ED officers are police officers. But that is for another court to decide. We cannot travel beyond the judgment." He told the court that the contentions advanced on behalf of the petitioners were based on the 2022 judgment. He said, and I quote, "There are two kinds of statutes in this area. Regulatory statutes like the Customs Act and the Foreign Exchange Regulation Act, and penal statutes like the Narcotic Drugs and Psychotropic Substances Act. I had contended before the court that ED officers are police officers subject to such provisions in PMLA which are inconsistent with the Code of Criminal Procedure. This is because they have been given the powers to investigate, arrest, and file a complaint in the nature of a charge sheet. This argument was rejected. The court held that the PMLA was a regulatory statute intended to protect the proceeds of crime and ED officers were not police officers. It had also held that investigation and inquiry were interchangeable. Mr. Sibal argued that the Enforcement Directorate's insistence on taking Mr. Balaji into custody flew in the face of the Vijay Madanlal Chaudhary judgment, in which the agency had received a favourable ruling. He said, and I quote, "They now say, after having argued and gotten a judgment that the ED officers are not police officers, that word investigation is there. So either Vijay Madanlal is right or they are right. They cannot change their position. This entire scheme under the PMLA is inconsistent with the Code of Criminal Procedure. Now they cannot bring in CRPC and insist on police remand for the purposes of an investigation." Mr. Sibal again reiterated that no provision under the PMLA allowed the ED to seek the police remand of an accused into its own custody in the same manner as a police officer or an officer in charge of a police station may do as per Section 167 of the CRPC. He said that law must apply to every situation and it cannot be made to measure. Meanwhile, Justice Bopanna agreed upon this and said that the court is not concerned with the person involved. Mr. Kapil Sibal said, and I quote, "Therefore, let's forget the person. This court has to lay down the law for posterity. This is why I'm rising above the individual issue here and trying to explain the whole purpose. The question is whether the ED is entitled to police remand at this stage. Can a police remand be sought, or will it only be a judicial remand? There is no judgment on this. This court will have to decide this in the context of the peculiar features of this act and in light of the judgments of this court, beyond which we cannot travel." Those were some of the submissions and arguments made by Mr. Kapil Sibal in the court. How the court decides the case based on these submissions will be covered in another update. Stay tuned to Live Law to know more about the courtroom exchanges and other legal updates on the topics you're following. That is it for now. We'll be back with more content on the Senthil Balaji case. Meanwhile, if you find our content useful, please like and share our videos. Also subscribe to Live Law on our YouTube channel and don't forget to press the bell icon for notifications. Thank you for watching.